I don't care who you are.
Off my fucking
I don't
property.
care who you are.
Right now.
You spit in my
Off
face.
my property.
You're
Right
going
now.
to jail now. He spit in my
Get off my
face.
pro-
You said you're
right in
going
my
to jail.
face. I'm spitting.
Roland Mumford with Mumford.law. Wanted to speak about the famous video going around about SeanPaul Reyes with Long Island Audit. And the big issue is that the Connecticut trooper, Fahey, was not charged with any particular crime. And the particular issue towards the end of his video is that he was arrested for voyeurism, breach of the peace, and trespassing. However, the big consternation was that the Connecticut trooper, Mr. Fahey, was not charged with assault or breach of the peace or any other disorderly for spitting on Mr. Reyes, or the matter of coming out of the home with that gun. The big issue that I want to discuss today is analyzing whether, in fact, that the Connecticut trooper, Fahey, should have been charged with breach of the peace or any other violation for spitting, and analyzing whether, in fact, is what the Groton Police Department had claimed, that under the Connecticut statute, the assault statute requires that there be some form of physical interaction, physical harm, and that it did not involve anything about spitting or physical contact that would be deemed offensive. I think that there may be a very good argument that Mr. Reyes would have is that the trooper, Mr. Fahey, had committed disorderly at a minute by spitting on him, and why did the Groton Police Department not charge him with that particular act? Let's take a look at the video to remind you what occurred, and then we'll get into it.
Now, as far as the allegations being made against Sergeant Brian Fahey, I was told through an anonymous tip that he is receiving fraudulent overtime every single year. Hey, Sergeant Fahey, how are you?
You gotta get off my property. No trespassing.
Nope, there is no posted sign. There's no problem. Do you have any, let's go. Do you have any comment on the allegations that you are, I am moving. Do you have any comment on the allegations that you are receiving? Film this guy. You're crazy. What do you think I'm doing, you psycho? You have a weapon in your hand? What do you think I'm doing, you psychopath? What do you think I'm doing?
Now. Get off my property right now.
Off your property.
This is my property.
Get that gun out of
Get
your
off
hand,
my
psycho.
fucking property.
Get that gun
I'm
out of your hand,
goddamn
psycho.
Connecticut State Trooper.
I don't care who you are.
Trespassing
I don't care
on
who you are.
fucking
I don't
property.
care who you
Get
are.
off my fucking
I don't
property.
care who you are.
Right now.
You spit in my
Get off
face.
my property
You're
right
going
now.
to jail now. He spit in my
Get off my
face.
pro-
You saw you're
right in
going
my
to jail.
face. I'm spitting as I'm talking to you.
No, you spit
Get
in my
off my
face.
property. Get
You're
off
a
my
psycho,
property
bro.
right
Look at
now.
the gun in his hand. That's
Damn
crazy.
right. I'm a Connecticut State
I don't
Trooper.
give a shit who you
are
are.
trespassing on my property.
That doesn't matter. You can't break the law.
Me.
I didn't.
You threatened to kill me online.
Don't
This is
spit in
the
my
biggest
face.
mistake you ever made.
No, it's not.
This
It's
is
the biggest mistake you have ever made. No,
Get
it's
off
not.
my property right now.
It's not the biggest mistake.
Get off
I've
my
ever made.
property right
It's
now.
not the biggest mistake.
Get off
It's like you
my
are spit in my face. You disgusting.
Your face.
You
I
disgusting.
was spitting at you.
Yeah.
I'm yelling at you to get off my
Yeah.
property. Right.
Get off. I'm off your property. Now what? Now what? Look at the gun in his hand.
All right, let's take a look at the Connecticut statute on assault. And I'm looking at this from the perspective of the Groton police officer told Mr. Reyes that they could not charge Trooper Fahey with assault, specifically because spitting does not fall within the context of the statute, and it is not textually prescribed in the statute. And the specific issue was that there was no physical contact involved that was causing harm. Now, let's say that that spitting by Trooper Fahey upon Mr. Reyes, and Mr. Reyes gets tested, and in fact that there was some type of communicable disease or such other that was transferred, and then we later learn after the fact that there was physical harm caused, meaning a physical condition, then in fact that would trigger the assault statute. So let's look at the statute, and we're operating from the presumption that Mr. Reyes was not harmed by the spitting. From what I understand, he was not harmed by it, but that could be subject to any tests that still need to be conducted. As we look at the statute in Connecticut for assault, and the caption gives the particular penal code, it says that a person is guilty of assault in the first degree when, with intent to cause serious physical injury to another person, he causes such injury to such person or to a third person by means of a deadly weapon or a dangerous instrument. Number 2, with intent to disfigure another person seriously and permanently, or to destroy, amputate, or disable permanently a member or organ of his body. He causes such injury to such person or to a third person, or under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which he creates a risk of death to another person and thereby causes serious physical injury to another person. Or with intent to cause serious physical injury to another person, and while aided by 2 or more other persons actually present, he causes such injury to such person or to a third person. Or with intent to cause physical injury to another person, he causes such injury to such person or to a third person by means of the discharge of a firearm. It goes on then to say that assault in the first degree is a Class B felony. Now, in most states, assault is creating an immediate apprehension of fear upon another person, where that person fears serious or even nominal bodily harm. But there is usually language in the assault statute that involves offensive conduct. That means an offensive touching. Here, this particular statute does not involve that. So I would have to agree with the Connecticut police officer. I would have to agree with the Groton police officer that in analyzing the assault statute at this time, without there being physical harm to Mr. Reyes, that the spitting did not constitute assault. However, let's look at the next statute, being breach of the peace. Let's take a look at that. Now let's discuss why I don't think that technically per the statute that Trooper Fahey violated the breach of the peace statute. In Connecticut, it's referred to as breach of the peace in the second degree. It's a Class B misdemeanor. When they said second degree, it made me think, well, maybe there was a first degree. And as you click on previous or next or look throughout the directory of statutes, I cannot find a lesser statute or one that is higher. Maybe that there's a reason for that. If there's a first degree, maybe there is. I cannot locate it. But this seems to be the statute that people keep citing online. So technically, Trooper Fahey did not violate this particular statute because of the language in the statute that prescribes public use of property or public area, that it has to be in an area that is for public use. Obviously, this occurred on Trooper Fahey's property. I don't think anybody can reasonably argue that his private property is for public use. So let's look at the language of the statute. A person is guilty of breach of the peace in the second degree with intent to cause inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, such person. And all of the language is here for the acts perpetrated by Trooper Fahey, but Mr. Reyes is at a disadvantage because of the public place language. Engages in fighting or in violent, tumultuous, or threatening behavior. All of that is there on the part of Trooper Fahey, but right here in a public place. Or assaults or strikes another, or threatens to commit any crime against another person or such other person's property, or publicly exhibits, distributes, or posts up, etc., or, and again, in a public place. And this language specifically states for the public, and the statute very clearly states, for purposes of this section, public place means any area that is used or held out for use by the public, whether owned or operated by public or private interests. Now, as I was researching this particular statute, reading some blogs by other Connecticut attorneys and so forth, there is some wide discretion with the breach of the peace statute, that it is very close and parallel to Connecticut's disorderly conduct statute. And that at times the officers have discretion to use the statute for acts on private property, but that usually involves a domestic violence situation between a couple. However, here we clearly don't have a domestic relationship between Mr. Reyes and Mr. Fahey. So it is my legal opinion that I don't believe that Trooper Fahey violated the breach of the peace statute. But I do believe that he violated the disorderly conduct statute and that he should have been charged with that. And now let's discuss that next. All right, now let's take a look at the statute for disorderly conduct, which is a Class C misdemeanor. This states, a person is guilty of disorderly conduct when, with intent to cause inconvenience, annoyance, or alarm, or recklessly creating a risk thereof. I believe that Mr. Fahey's actions meet the definition of annoyance or alarm, particularly alarm. Such person engages in fighting or in violent, tumultuous, or threatening behavior. Mr. Fahey's acts of coming out of that home with a gun and spitting on Mr. Reyes absolutely has to meet that definition. Or by offensive or disorderly conduct, annoys or interferes with another person. That, at a minimum, the spitting on Mr. Reyes is certainly offensive conduct as well as disorderly. Makes unreasonable noise. Certainly, Mr. Fahey perpetrated acts that would meet that definition. Or, without lawful authority, disturbs any lawful assembly or meeting of persons. I don't believe we have that. Obstructs vehicular or pedestrian traffic. We don't have that. Congregation with other persons in a public place. We don't have that. Or commits simple trespass. We don't have that. So, I believe that when we look at, again, subparagraphs 1 and 2 and 3, I believe, in my legal opinion, that Trooper Fahey violated these acts and should have been charged with disorderly conduct. And this statute does not have a public use of space requirement. Now, ordinarily, disorderly conduct, it does involve actions in a public space in many state statutes. But in this particular statute, we don't have that requirement. So that's my analysis. I don't believe that Trooper Fahey violated the breach of the peace or the assault statute as it is technically prescribed, but it is my legal opinion that he violated the disorderly conduct statute. And I believe those officers should have charged him that on scene, since they clearly had the time to analyze whether spitting constituted assault and how they looked at that statute specifically about that. They clearly had the opportunity to review the disorderly conduct statute. Now, I understand that many of you may come at me with some negative comments, but I have to be an attorney with intellectual honesty to maintain my credibility about criticizing police officers and violating individuals' constitutional rights. I have to be honest. So please respect my comments. I hope that I have analyzed the statutes as you have seen textually to understand where I'm coming from. Thank you very much for your time. Help me reach that 10,000 subscriber goal by July 31st. Have a great day.